Hi, this is Diesel for We the People News. Okay, before we start off with anything, alright, this video is without prejudice and recourse, waive none of my rights. Alright, this video consists of a Center for Parental Responsibility. Okay, now I do not agree with 100% on this. I believe no government or corporation can force you into any contract whatsoever. So even though they kind of want to do a repeal and all this on the 4D thing, number one, I think they ought to scrap it, and if they're going to do something about it, then they need to start all over, because everything within the 4D contract by force is unconstitutional, state and federal. You cannot be forced in contract, y'all. I'm a firm believer. Before getting married, study the 4D. During marriage, study the 4D. After marriage, study the 4D. Because to understand the 4D, whether either sides have attorney, the attorney is for the state. So if your ex has an attorney and your ex believes that the attorney is for her, but in all actuality, it's going to be operating on the judge's side because they have a contract with the state of Texas from the federal government, and any counties that's involved in this contract must agree to the terms of the state and federal, which is conflict of interest, y'all. This is the reason why you don't have due process in family court. Alright, this gives you an idea of what to expect. Okay, and I believe this woman's pretty much right on cue, and I suggest you guys go to their YouTube channel and give support to them, and maybe see some other videos about some of this, maybe have or not have. I just really seen this one video and I watched it and liked it to share it. So you guys hit the like button on this, but definitely go to them. I don't care whether you hit like button or not on mine. You know, this is for y'all's benefit, because this does not benefit me whatsoever. I'm not involved in it. Alright, I'm just sick and tired of the federal government and the states forcing you into some type of agreement, okay, which they lawfully do not have authority to do. And it's getting worse and worse every day because everybody keeps on forgetting their own personal liberties and rights. Alright, and I want to try to get this as best as I can, but I'm limited on means and all that kind of stuff. Alright, so we're going to go ahead and proceed forward. This is a long video, y'all. So watch it a couple of times, every now and then or whatever. Alright? Sorry.
The following presentation explains a huge problem concerning an out-of-control federal government welfare program called child support. This presentation will provide a simple solution to that problem. Child support has grown...
Okay, before I get going, I'm sorry. I'm not an attorney. If you're not age majority, go get an attorney. Alright? If you have age majority and it's out of your league, maybe seek counsel. But remember what I told you during the beginning of this video, right? They are working on the state's behalf, but I'm not an attorney. I am not giving legal advice. It's just my opinion only. Okay? So, it's a learning video also, by the way.
Like a cancer in every state across the United States, now doing the opposite of its intended purpose. It was designed to reduce the cost of welfare paid by the government to single moms when the fathers were absent and not involved, but is now increasing costs dramatically. It also claims to help children, but in reality, the federal and state child support bureaucracies have become harmful to children, primarily using this program to undermine the father-child relationship. The child support problem is so out of control, it is begging for a solution, and I have a great solution. This video describes 1. The history and evolution of the federal child support program, 2. Why it is referred to as Title 4D, 3. How this program impacts state child support laws and policies, 4. The congressional purpose of the 4D program, explaining why child support is not for children and never was intended for children. 5. How the program has expanded far beyond congressional intent. 4D services were never meant for involved fathers who willingly provide the basic needs for their children. 6. The problems that arise with this 4D child support program on both a federal and state level. It is the only welfare program with no income eligibility standards. Because of this, anyone and everyone who applies is granted the whole range of collection services. This has become incredibly harmful to children and an enormous waste and abuse of taxpayer money. 7. To conclude, I explain an easy solution as a first step by creating income eligibility standards for government child support services where none exist today. While this presentation was given in 2005, it is still completely relevant today. I encourage you to watch the entire 1-hour presentation to educate yourself about the basics of this program. This is information the Child Support Agency will never tell you, but you need to know if you want to be part of any meaningful reform. Today's topic is Title 4D Welfare Services. I'm going to answer 2 questions in the next hour and a half. And those questions are, first of all, does the federal government allow the state to initiate reform and clarify eligibility standards for Title 4D welfare services? The second question, will state legislators be assured the state won't lose the entire federal funding for 4A and 4D as the state DHS alleges? As we go through those 2 questions, the first question, I will review the outline listed here. We'll review family law versus welfare law, public rights versus private rights, the history and purpose of 4D as it is in the Social Security Act, the limitations of Title 4, Title 4D amendments, the unauthorized expansion of the 4D program, outcomes that produces regarding process and fiscal outcomes, and then we'll talk about the constitutional violations created as a result of that overreach. The second question I'll review and outline that will answer and describe for you the CPR solution, what the DHS claims, what the misrepresentative federal penalties are, what they look like, the positive impact that change and reform would have on government budgets, and also hopefully we'll have some time to discuss some fiscally responsible decisions that we can work with together. I want to begin with a disclaimer and make sure that you know that I am not an attorney and nothing I say today should be in any way, shape, or form considered legal advice. Though we have run through all of our information by our advisory board attorneys, several people who were able to work with and give us that legal input. I have also received information from 3 judges, 2 retired district court judges in Minnesota, 1 retired appeals court judge in Minnesota that believes that our information is accurate, and we continue to expand that base of interested judges and lawyers, although I found that retired judges are more willing to talk to us. The first question, does the federal government allow the state to initiate reform and clarify eligibility standards for 4D welfare services? The first subject in that area is family law versus welfare law. At the legislature, you've heard a smorgasbord of family law issues. There's child support legislation that Senator Neville has done an incredible job working with, which mostly focuses on the guidelines, whether it's a net income, income shares, cost shares, whatever it is. Then there's been legislation on joint physical custody. There's been legislation repeatedly year after move-aways, and really many other family law related issues, things as like OFPs, parenting plans, imputed income, a host of different topics that affect family law or that are part of family law. And last but not least on this list, of course, is Title 40 welfare reform. And I put this slide up here on purpose to show you that Title 40 welfare reform is different. It's something separate from all of these other issues, so it does not need to be in conflict or worrisome with any of the other legislation that we do also get involved in. I want to begin by saying also that we at CPR believe that both parents have an equal duty to support their children. And nothing that we are promoting or nothing that we are suggesting in Title 4D reform will at all impact that philosophy that both parents do have an equal duty to support their children. Title 4D is the child support enforcement and collection program put together by the federal government. So it's a federal program that's state supervised and county implemented. You're familiar with those kinds of programs. The Title 40 welfare program causes some problems or causes some myths. It's based on some presumptions that carry through the whole implementation of 40, which causes concerns for us, and I'll go through a few of them here. The Title 40 system is premised on the assumption that moms have custody, and I'll go through later why that is. The 40 system is based on the belief that women are unable to self-sustain. The 40 system is based on the myth that dads don't want to parent and are only minimally involved with their children. And the 40 system is contingent on the fact that one parent is labeled an absent parent. The 40 system is based on the erroneous belief that dads won't support their children unless they're forced to pay. In fact, in the early 1970s, when they were looking at the 40 program for the first time, the National Organization of Women testified before Congress regarding why these child support laws were needed. And they testified saying that because they were getting, just by default, having custody of all these children, they made it clear to Congress that their views at that time were custody of the children to the mother is not an award, it's a sentence. That's why they created the 40 program at the federal government, to try to rescue these women from the burden of custody. The other premises or myths or basis of the 40 system include those that are on here. What it does and the problems it creates is it builds a huge bureaucracy that supports one parent at the expense of the other. It gives the custodial parent a sense of invulnerability because they have this whole bureaucracy on their side. It creates increased animosity between parents, pitting one against the other, driving a further wedge because you've got that whole system that's constantly initiating actions that the custodial parent hasn't even initiated themselves. This creates a deeper conflict, and conflict is what's worse on kids. Conflict is worse on kids than divorce itself. And the 40 system then is based on the concept that the custodial parent will get everything because, remember, and you'll learn as we go through the presentation, that the assumption is the dad's not around. The 40 system, because it provides all these things for the custodial mom, provides everything for the custodial mom, and I say mom or dad, if I say those words erroneously through my presentation, there are non-custodial moms and there are custodial dads, but sometimes I slip up and use gender-based language, mom and dad, and that's only because, according to the University of Minnesota, 90% of the divorces and paternity cases in Minnesota result in custodial mom. So forgive me if I use those a little too loosely at times. The 40 system, probably the worst thing, and why there's so much of an uproar on this, is the sense of fairness is absent in the 40 system because the power of equities are not used in administrative law. And all these proceedings are done in administrative hearing process. The next section is public rights versus private rights. I just want to review that by saying that there's two different kinds of law. There's public rights and private rights. Public rights where there's a government interest, and private rights where there's no government interest. If one company, one small mom and pop shop is suing another because somebody slipped on their sidewalk or whatever, it's going to be all handled in private law. The government's not going to be involved in that. And there's also, with regard to the difference between public rights and private rights, I'm sure I don't need to review this for you because you're legislators and you're here and you know all this, but in private rights, everybody's protected by the Constitution. And in public rights, everything is statute driven. And in public rights, when the government is involved, there's always a compelling state interest. There's always a protectable interest by the government, a pecuniary interest, a safety interest, an interest for the general welfare. But the general welfare has limitations according to the law. And on the far right-hand side there, private domestic relations has been left up to the states. The federal government, according to the Constitution, does not get involved. And here is a report from the Congressional Research Service out of Washington that says, under the U.S. Constitution, Congress has little direct authority to legislate in domestic relations and family law issues. That's the private matters. And that's clear the way our Minnesota statutes are written. In chapters 245 through 267, it's all about public welfare when the government is involved. In chapters 517 through 519, the revisor's office has labeled those chapters in the statute as private domestic relations. The problem is that in our state law right now, we've run into a problem between mixing public and private rights. We've got the public welfare in the 256 chapters, and we've got private domestic relations law, which started out in the 518 chapter. Now we've suddenly taken what was meant to be public law, which the Title 4D law, and we've embedded it into 518, so we've blurred those lines. We've crossed that bright line of separating public versus private rights, which is causing a lot of confusion. Public rights and private rights, when it comes to family law, become very different. In private rights, you get a judicial proceeding in front of a district court judge. In the 4D process, you only get an administrative hearing in front of a magistrate. And by the way, the 4D magistrates in the administrative process are all paid for by the pool of money that is developed through the child support collections money that's put through the system. We'll get to that more later. In the judicial proceeding, the judge can rely on his equitable powers. In the public rights in the 4D system, in the administrative process, the magistrate has no authority to rule on their equitable powers. Everything is statutory only. No constitutional issues can be heard in that court. They can only be heard in the judicial proceedings. And what's most disheartening for many people that end up in the administrative process is, according to the expedited rules in the state of Minnesota, hearsay is allowed. So there's a lot of families that are impacted in incredible ways based on hearsay, which that's where this sense of unfairness comes into play. So how did this all start? Where did 4D come from? 4D is from the Social Security Act. The Social Security Act was started in 1935, and we have a team of researchers. We've got 7 people on our research team that have researched Title 4D for a cumulative 38 years when we add all of our time together. So we've spent the time trying to understand this, to figure out what has happened. Well, the Social Security Act was started for the purpose of providing a social safety net for low-income people. It was to take care of those that were dependent members of the population, and dependent meant dependent on the government because they could not take care of themselves due to poverty. So it was a way, the Social Security Act is a way of protecting those people, as we have learned, on a temporary basis for a period of time in their life when they can't do it themselves. The way the federal government decided to eliminate the major causes of dependency was to start out with the following sections of the Social Security Act. One was the Old Age Security, which we most all think about when we think of Social Security Act. Second, they started unemployment right away. They started the security for children right away, and they started a public health segment and a couple more as well. But the whole idea was to provide marginal, temporary, but regular income for individuals in need. So when I talk about Title 4D being part of the Social Security Act, we're not talking about affecting the old age retirement program at all. It's two separate programs. Right now, there's 21 titles in the Social Security Act, and what we're talking about is Title 4 of the Social Security Act. That is Title 4, which is the rubric for that is needy families and child welfare. I can tell you exactly what that says, but that's the focus for Title 4. So Title 4D is a segment of Title 4 of the Social Security Act. Title 4D is child support collections and enforcement, to give you kind of a picture of how this all fits in. So what are the limitations of the Title 4D Welfare Service Program? Well, as our researchers went back and studied this, not only back to 1935, but we've been back to 1912 to try to understand the whole evolution of these programs. Title IV was created by the federal government, and it was for a limited class of people, for needy and dependent people, to ensure their basic needs. And then we've got lots of references on how the whole Title IV is limited to those in need and those who are dependent on the government. Sometimes that word dependent gets confused when we talk about dependent children, because people think of dependent children as anybody 18 and under. But that's not true for Title IV of the Social Security Act. We're talking about dependent children, dependent who have no parents to provide for them, no relative to provide for them. So here you can see the legislative history here where it's limited to need independence. Here's another reference from legislative history of the Social Security Act, talking again about needy, dependent children. That was the appropriation for Title IV. So then we need to look at two different words, needy and dependent. What are those? According to a private independent report going back to 1946, as they were studying the Social Security Act, they made it clear in that report, and many others I might add, that need was defined by a strict definition. That definition in Minnesota law was clear in 1937, that a dependent child not only was under the age of 18, but was deprived of parental support because of continued absence from the phone from the primary wage earner, and not not just, or not eliminating, but and whose relatives, nobody's relatives, no one is able to provide for them without public assistance. That's the purpose of Title IV. So that dependent child, here again, in Minnesota statute even today, where they're not able to provide for the child. In 1974, the federal government looked at Title 4A of the Social Security Act. Now, Title 4A is the section for TANF, Temporary Assistance for Needy Families, or AFDC was the old title for that. And in Minnesota, that's where the MFIP would come from, where all of the laws and all of the funding for MFIP come from Title 4A. So in 1974, which was right after the sexual revolution, the federal government was looking at their Title 4A rolls and saying, wait a minute, we have so many people on here, this is exploding. We're giving so much assistance to so many, this is unsustainable. So the federal government decided to do a study on Title 4A to say, who are these people? Who's getting these services? What they discovered is the majority of the people in Title 4A getting what we know of as welfare services were a result of out-of-wedlock births, single moms with children, dads were nowhere to be found, dads abandoned the family, all moms had custody by default because dads weren't there, dads failed to provide financially, they weren't around, and therefore mothers and children had been abandoned to public assistance. What they found out later is the only way the moms could get public assistance was if the dad wasn't there. So a lot of the dads, when they used to knock on the doors and say, hey, we're just checking up on you, the dads were actually up in the attic or hiding in the closet, so they weren't really even absent. So a lot of these assumptions that they've made to build the program on must also be questioned. So what they decided to do, the federal government said, aha, we have all of these people on 4A welfare services, and the dads out there, they should be paying. The dad should be paying. So they started the Title IV-D system in 1974 based on the following assumptions: that women cannot get work outside of the home, that women are expected to stay home with kids, that women are unable to self-sustain without assistance of the government or a man, that the men are always the primary wage earner, that dads do not participate, and all married dads are deadbeats. Those were the assumptions on which Title IV-D was built. And I think today we can see that most all of those presumptions must be questioned. So it must be questioned how the evolution of this program has gone even far beyond that. So this is where we're at, Title IV-D of the Social Security Act. In 1974, when they developed the program, then they developed it for two reasons, the federal government, for two reasons and two reasons only. One, to protect those single mothers with kids on welfare and those at risk of falling on welfare if they don't get their child support. And the purpose of protecting those with child support services who are on welfare is cost recovery. If the mom and their child were getting $500 a month from the government wanted to go after those dads to get that $500 to reimburse the public fisc. Then they also, so that's cost recovery. Then the second limited class of citizens for Title IV-D was the non-welfare group, which was those at risk of falling on welfare if they don't get their public assistance, which is cost avoidance. Very clear. The source I have at the bottom of this page is the General Accounting Office, but the sources go on so far, it's abundantly clear. I'm going to show you some ad nauseum, and you're going to wish I didn't give you so many here. But I wanted to let you know that has always been the goal. It's never changed, and there's huge support for it. This is from a Washington state case law where they clearly articulated that the 4D program was for those receiving public assistance and those where there would be a real possibility that the custodial parent would fall on the welfare rolls. The Supreme Court of South Carolina also came with another case and said the same thing. For 4D services, the applicant must be eligible for 4D or for AFDC if not likely to need public welfare if the support is not made. Just more evidence of what I'm saying is true. So I've given you three sources here about the intent and purpose of the Title IV-D. And we have, as I said, many other sources. If those aren't good enough and you want more, let me know. We'll give them to you. So if those are the limitations of the program, cost recovery and cost avoidance, that is legitimate use of the program. We're totally in favor of that. We don't want to do anything to change that purpose. We believe that that's valid. There's a compelling state interest. There's a protectable interest. There's a pecuniary interest that affects your pocketbook and my pocketbook, whether it's the state pocketbook on the left or the federal pocketbook on the right. In our Minnesota statute, it's very clear that all of our 4D laws must follow the federal law. So federal 4D law actually supersedes state 4D law because we're only doing our law to implement the federal law. Right in our code, it's very clear that everything in 4D is done under Title 4D of the Social Security Act. So the controlling authorities for Title 4D are very clear and easy to find. Thank goodness for the internet. We can do gobs of research that way. With the state constitution and the U.S. Constitution always being the borders for everything that we do, Title 4D law is clear with the actual law itself. And in 42 U.S.C., the Chapter 42 of the U.S. Code is where you find all of the 4D law. Chapter 45, the federal regulations, you've got state law, administrative rules, and then agency policies too. So we've been able to track all those things to try to understand where's this all been, where's it at now, and what's going on. So we've got no problem, again, for using the Title 4D program for cost recovery and cost avoidance. The next thing that you might ask is, well, that's all fine and good, but there's probably been some amendments. 30 years have gone by. What amendments have occurred? Well, our research team has studied the amendments as well. In fact, it has been said that the original Social Security Act was 12 pages long, and today, if you were to take the paperwork of all the amendments of the Social Security Act, it would reach from here to the moon. So yes, there has been amendments. We've studied the specific Title IV-D amendments going all the way back to 1974. I've tried to summarize some of them here for you today. In 1984, there were many changes in the Child Support Amendment. And one of the things that is causing confusion with these amendments is this kind of statement here in red, that this amendment changed things. The federal government tried to change things so that the demand for equal services, so that the demand for equal services for welfare and non-welfare could be fulfilled. Okay, but what the Minnesota DHS is coming back and saying is, well, in 1984, the federal government made us provide these services to everybody, welfare and non-welfare. They changed the laws in 1984, is what the Minnesota DHS is claiming in individual sessions with you and others. Well, our research team has done the research. We went through the entire legislative history with all of the federal documents to figure out what was intended and what was meant. Well, it's clear on the record that the record is filled with these kinds of comments here, as from Senator Dole, that the purpose of this 1984 amendment was to place new strong emphasis on the non-welfare caseload, because when child support payments are missed or never received, that can make the difference between remaining independent of welfare or being forced back onto public assistance. So do you see how he was really referring to the at-risk group? And if you pour through the legislative history, you'll find these kinds of comments over and over and over again. There's nothing in the 1984 amendments that show that they expanded the class to include every child in the universe. Another one of our own favorite Minnesota senators, Dave Durnberger, is also on the record, and he has a similar comment. In his statements, he talks about the same thing, how women who are divorced or have had out-of-wedlock children, they cannot find work. And especially those that have been married for a while and been stay-at-home moms, that, they'll be forced to public assistance if we don't help them continue to get these support payments. They'll fall on welfare again, and we don't want them to fall on welfare again. We want to decrease that dependency. I've spoke with Senator Dave Durnberger, and he supports our research and our interpretation of what has happened all along the way. So hopefully that will give you an idea of what really happened in 1984 without getting into too many details. There's lots more details I could talk about. So then we continue with the amendments. In 1996 is when Clinton came out with the Welfare Reform Act, also known as the Personal Responsibility and Work Opportunity Reconciliation Act. So they mean the same thing. If you see them, they're interchangeable. In 1996, people that I've talked to have said, as I've talked about the evolution of the 4D program, they've said, well, Clinton changed everything in 1996. Didn't you know that? Well, we've done the research. Our research team went through again the legislative record to see, did anything happen in 1996 that made the 4D program required to be applied to everybody in the universe? Well, in testimony in April of 2003 in front of the House Human Services Policy Committee, a representative from the DHS, who's no longer there, said Congress made it abundantly clear in 1996 Welfare Reform Act that 4D services had to be provided for any individual who applies for application. That was the DHS testimony in a hearing in this room, maybe even. However, we've done the research and we're not able to find it, and they have not been able to provide exactly what that is. We have found instead that in 1996, Clinton's whole purpose was time-limited assistance and increasing individual responsibility. One of the things that we found as we've poured through the amendments from 1996 is just more information to support our position. For example, this is a section of the public law that's been changed and modified. What they did is there was so much confusion on what do you mean by dependent